Well, good morning. I'm sure there's been a time, no, I'm not, where I've looked out on more friends and people I admire and have worked with forever. And it's great of all of you to come, and boy, what a great thing to celebrate. I can't tell you how privileged I feel to be making this talk. There's no doubt about it. The pivotal moment in my life was in October 1971 when I walked through the front door of 1506 Broadway as a new staff attorney at the Native American Rights Fund. I have no words to express the personal satisfaction, the love, the beauty that I have received from Indian people. And all of us lawyers in the field know that's the secret of look who we get to represent. And the joy and beauty, too, from their treasured tribal sovereignty. I'd like to pay tribute as we celebrate these 45 years to David Getchus, Tom Fredericks, and John Echohawk, the only people who have ever served as director for this great firm. And each of them in their own way was a force from the beginning and have throughout their careers carried the high ideals of NARF as they've worked for Indian people. Thanks to each of you. They had nothing. They had nothing. They had nothing. I'm writing a history of the Bolt decision, and last spring had the pleasure of spending some time in Seattle where I could interview some of the people involved in that historic litigation. During those separate interviews, 3 different attorneys, 2 from tribes, 1 from the state of Washington, independently volunteered and emphasized those words I just spoke to you. They had nothing. I asked each of them to explain what they meant by that phrase. They mentioned the grinding poverty. By the way, 60% unemployment would be a conservative figure in Indian country for 1970. They variously mentioned physical factors such as the universal lack of indoor plumbing and electricity, the absence of paved roads, and the housing, so much of which could be classified as shacks. They also emphasized the health problems and the very limited educational opportunities. They pointed out other factors indicating the terrible state that Indian people in Northwest Washington faced. Of course, Indians all across the country were in similar conditions. They had nothing. It was exactly that reason that caused Vine Deloria, Charles Loha, and David Risling, and a few other Indian people to establish a national organization dedicated to vindicating the legal rights of Native American people and tribes. Of course, although Indian people lacked a great many things back then, it was not literally true in the late 60s and early 70s that they had nothing. In fact, they had the most important thing: their vibrant cultures, demeaned and battered, to be sure, but still very much part of their minds and hearts. Nonetheless, the national government, the states, and local citizens had taken away a lot and suppressed a lot of what was left. They took away the indigenous economies. Even today, Indian people, when asked how to describe their well-being before white people came, will say that we were rich. That is an economic fact, not a romantic construct. And because those early economies were much more elaborate and substantial than is commonly realized by non-Indians. In the Pacific Northwest, for example, tribes developed elaborate economic markets reaching south to the Columbia and north well up into Canada, to the crest of the Cascades and beyond. Markets for the trade and sale of deer and elk and cultural objects, and especially salmon and other marine specialties. Then the new people came, and after spending decades benefiting from the vigorous native economies, overran those economies with their technologies and capitalism in ways we can't fully comprehend. The outsiders never could get beyond the ironclad assumption that Indian people were inferior to the God-given mission of the westward expansion that was intended rightly to eliminate all native institutions, regardless of how valuable they in fact were. They took away the land. They didn't get it all because the tribes continued to have enough military capability at treaty time to prevent that. After the treaties, many people, both political leaders and common citizens, stoutly believed, and there is far too much truth in it, that if you took away the land, you could eventually take away the culture. John Wesley Powell, the great explorer, policymaker, and philosopher of the West, was explicit about it. He strongly and cravenly, explicitly supported allotment in the late 1880s because, as he wrote, if you could wrench away the land, especially the sacred places, you could wrench away the culture as well. That would, as he and others believed, hasten the moment when the vanishing Indian would become the vanished Indian, which, after all, was the ultimate objective of national policy. They all outlawed many of the old ceremonies. Is there a darker moment in the story of the First Amendment than the relentless regulatory crackdown on native dances, and other customs. Some traditional practitioners carried out their ceremonies in the dark, in basements or other hard-to-find places. But for many, the threat of punishment from the United States of America was too real and too severe. Besides, the crackdown came in other forms, such as in the Pacific Northwest, where BIA employees simply torched traditional dance halls. They suppressed the languages, the ultimate expression of culture and worldview in all societies. BIA and boarding schools prohibited native tongues, washing out the mouths of young people with yellow lye soap when they spoke their own languages. Government officials and people in town scorned native speakers. They directly operated on the families. Parents and children were both pressured hard to send the young people to the boarding schools, meaning that these family members would be taken out of the home for most of the year. In the schools, they would suffer nothing short of indoctrination. The students would be told, don't pay attention to your grandparents. They're just old-fashioned. You can be a real American. Inexcusably, federal officials stood idly by in the post-World War era when states and churches began aggressively removing, sometimes amounting to kidnapping, Indian children from their homes and obtaining state court adoption papers in favor of non-Indians. They took away something else. They took away hopes and dreams and optimism and individuality. They took away, at least they tried, the right to be yourself. And by the late 60s and early 70s, many policymakers and legislators were still defending and pursuing the current and ultimate policy adopted by Congress in 1953, outright termination of treaties, reservations, and federal obligations to tribes. It was in this cauldron of experiences that the Native American Rights Fund was born 45 years ago. Vine Deloria Jr. put it right. We better win this one, because if we don't, there won't be another. Not that NARF was seen as the be-all and end-all. Many organizations would be needed, as well as building capability in the tribes themselves. Still, tribal leaders at that time, as they do today, placed great emphasis on the need for lawyers and law reform. Indian people and tribes are subject to so many laws and regulations, and the field is known for its complexity. The new legal services firms on or near reservations, when NARF was formed, were already making their presence felt, and some capable attorneys practiced Indian law in private firms. The hope, and this hope has more than been borne out was that NARF could play a particular role in addressing national issues, becoming a substantial firm with excellent lawyers and representing Indian individuals and tribes who needed attorneys on pressing matters that raised issues of national importance, but could not afford to pay lawyers. From the beginning, one of NARF's strengths has been its vision in prioritizing its work to meet the situation just described and, over time, adjust the work to meet changing circumstances as tribes made advances and new kinds of needs and opportunities emerged. This ability to meet the particular circumstances of particular times becomes ever more evident when we look at NARF's accomplishment in the early years up through today. NARF's work has also been marked by what was, it's my sense, an unexpected result. At the time, lawyers in private practice, and back then private practice was mostly what law was, attorneys' work was mostly self-contained. You worked on a single project, like a contract, will, corporate charter, or lawsuit. The results might benefit the client, maybe a lot, but they would be mostly limited to the results of that specific project. It turns out that NARF's work has been much more than that. This was partly because it involves public law rather than private law, partly because of the circumstances in Indian country. One example, though it is somewhat more diffuse than others I'll mention, involves one of NARF's core concerns, tribal sovereignty. We have seen over these 45 years how an advance in one discrete area of tribal sovereignty, be it education, health, water rights, jurisdiction, or other, that one victory will likely increase, even if slightly, the general respect for tribal sovereignty on the part of outsiders, influential people, common citizens. And over time, respect for tribal sovereignty will arc toward the establishment of broader and deeper substantive tribal sovereignty. Now, from the vantage point of 45 years, we can see this dynamic in technicolor, from the time NARF started to the way it has played out today. The extraordinary 1974 ruling by Judge George Boulder in the United States against Washington that mid-19th century treaties guaranteed to tribes in the Northwest the right to harvest 50% of the salmon has turned out to be even more historic than that fundamental decision seemed to be at the time. Judge Boulder, for example, also ruled that tribes, as sovereign governments, could regulate fishing. Immediately, the tribes leapt into action and formed natural resource departments, drafted regulations, set up enforcement systems with officers, hired fisheries scientists, and upgraded or created new tribal courts. These were perhaps the first modern regulatory systems in Indian country. Then, seeing how well the fisheries agencies worked among individual tribes, the Northwest tribes began setting up tribal agencies for education, health, land use planning, and other purposes. They joined together to form the Northwest Indian Fisheries Commission with deep expertise in science and policy, one of the first intertribals. So, over time, the original decision in U.S. against Washington spread. And among other things, today led to the comprehensive regime in the Northwest for co-management of all fisheries among the United States, the tribes, and the states. The changes went beyond fisheries. The Northwest tribes now have elaborate and substantial sovereign governments, with most of them having 300 or more governmental employees, not including enterprises. Tribal leaders regularly point to the Bolt decision as the triggering point for their broader modern revival. To be sure, NARF has never gone it alone and virtually always has coordinated with other people and organizations. In the Northwest, Billy Frank Jr. and other tribal leaders and activists, and Judge Bolt himself played major roles in that litigation, in the U.S. against Washington litigation. So did legal services and private practitioners who were willing to bill tribes far below their normal billing rates for work on that case. But David Getchus was lead counsel, and he knocked around many ideas with people back in Boulder. And to this day in the Northwest, people honor NARF's central role in that lawsuit that led to a thoroughgoing reorganization and restoration of tribal organizations reaching far beyond the bounds of the actual issues in that case. Much can be said about NARF's contributions then and today in being significant contributors to, therefore, the tribe's national movement across so many areas. The dynamic was at work in the United States against Michigan, where NARF played a sturdy role in that case, and the tribal revival in the Upper Great Lakes area. So too with Menominee Restoration in 1973, which led directly to the restoration of all terminated tribes, the recognition of non-recognized tribes, and the formation by all of those tribes of active and effective sovereign governments today. Menominee restoration never could have happened without the energy and talent of Ada Deer, Sylvia Wilbur, and other Menominee leaders and activists. But NARF played an effective role there. Many of the revived Eastern tribes have built their modern operations upon the Eastern land claims cases, where NARF broke new ground. At Pyramid Lake in Nevada, the Pyramid Lake Paiutes and the leaders achieved true, comprehensive watershed restoration in the Truckee and Carson drainages, and then put together expanded tribal governments in the fashion scene in the Northwest and elsewhere. But it never would have happened without the all-out commitment in the litigation, to the litigation that the Native American Rights Fund provided. By the mid-1980s, Walter Echohawk, with help from Steve Moore, was hard at work fulfilling one of Walter's life dreams, combating the scourges of excavation and stealing traditional cultural objects and human remains. Numerous lawsuits and litigations finally funneled into the Native American Graves Protection and Repatriation Act of 1990, one of the most luminous accomplishments by NARF and all of Indian country. Essential to NAGPRA was the effort put in by religious practitioners who patiently explained, often in their own languages, the horror of the problem and how deeply Indian people wanted to make inroads into it. It also was an occasion where the beauty of the law, which we do not often enough witness, can be seen in full flower, that is due primarily to the legal genius, traditional roots, and all-out commitment of Walter Echohawk, who, through NAGPRA, changed the world. Over the last 20 years or so, NARF has both solidified its position as a main guardian and coordinator for the whole field of Indian law, and as well has moved into new and exciting areas. From the beginning, NARF was a watchdog for the whole field. For example, doing amicus briefs in for every Supreme Court opinion, and trying to work with other attorneys to have, as best we could, with so many attorneys coming forward, which is a positive thing, but also harder to coordinate. And NARF trying to help that approach. At the same time, NARF has continued its sacred obligation to represent tribes with limited resources and significant legal needs, and as well as maintaining its centrality in the national Indian law community. Eventually, we saw a change from NARF doing those amicus briefs, which many people commented on as being always read by the court. And NARF does still do amicus briefs, and important ones. But since 2001, we have had the Supreme Court project, where NARF has a lead role. No, we haven't got a lot of great results. but that is due to the court, not us. This project, with attorneys across Indian country working together, has built a solid system for putting our cases before the court in the best possible light. Strategies such as whether and how to handle cert are addressed in great depth. When the court once takes the cases, briefs, including amici, are identified and assigned to different people, and they're polished, and the cases are then argued by the best lawyers. It isn't easy. The 90-party conference calls are horrid. I heard 90 people laugh. But the Supreme Court project has become a necessary, effective, and permanent cornerstone of tribal advocacy. The trust relationship has long been under fire, and we must protect that foundational doctrine as best we can. NARF sees itself as the watchdog for the trust, and large results followed from Eloise Cobell's call to John Echohawk to do something. In the end, the individual allottees in the final settlement received less than they deserved, but the payments were reasonably substantial. There are creative provisions built into the settlement. The land buyback provisions have already returned 1.5 million acres to tribes, and there is more to come. Most of the tribal, as opposed to individual cases, and the tribal cases were legally difficult, have settled, and the results have been highly satisfactory to the tribes. NARF has taken a leadership role in yet another foundational and complex area, the settlement of tribal water rights cases. From the beginning, tribes looked to NARF for leadership in the water area. In the 1980s, NARF made contact with the Western Governors Association and the Western States Water Council, and they joined in an effort to set a context for settlements in recognition of the fact that for all water users, including developers, states, and tribes, settlement can often be the preferred alternative over litigation. A major conference organized by NARF has taken place every 2 years, and the doors of water users, state offices, and the tribes remain open. Congress has enacted 29 major water settlements, with NARF attorneys handling 9 of them and others and offering advice in most of the others. There's still more work to be done, and NARF will be right in the middle of it. Native people know their homelands, and far more than most citizens of this country understand the destructive march of climate change. Tribal villages in Alaska, Northwest Washington, and elsewhere have already been affected by rising ocean levels. All across the country, Indian people who know the land are seeing and feeling the impacts on forests, rivers, rangelands, and animals. NARF is working to assure that sustainability will be eventually reached, and that the tribes will be treated as sovereigns in state and federal assessments and planning for public land and water resources. The climate change work dovetails with NARF's involvement in international issues, where since 1999, the organization, often representing NCAI, has been active in the adoption and implementation of the UN Declaration on the Rights of Indigenous Peoples and other matters involving indigenous peoples globally. Among other things, for the past 6 years, NARF, with Kim Gottschalk doing a good part of the work, has steadfastly participated in the elaborate UN Framework Convention on Climate Change process. Progress has been painfully slow, but the stakes are high, and NARF will continue to press for full recognition of the special circumstances and rights under the UN Declaration of American Indians and other indigenous peoples. As you know, there's much more to tell about this extraordinary organization that has changed the world. And obviously, I can pretend only to make a beginning on it this morning. But oh, would I ever be remiss if I didn't mention another part of NARF, the Anchorage office, NARF North. The specifics vary across Indian country, but every tribe is burdened in some significant way by the weight of history. Alaska is as bad as it gets. ANCSA of 71 was an abject horror, and for nearly half a century, federal officials have used every part of it they can find in order to brutalize native land, sovereignty, economy, and culture in their campaign against native tribes and people. Larry Ashenbrenner and Bob Anderson staved off a lot and made some progress, and they did it with gusto. Now, we have these 4 wonderful lawyers up there, Heather, Natalie, Aaron, and Matthew. They've taken on about every issue you can name in that big state, from voting rights to Indian child welfare to water, fishing and hunting, and land into trust. And somehow, ultimately, after the Supreme Court's Venati decision, about as wrong-headed and devastating as a court decision gets, they have impossibly, piece by painstaking piece, made significant progress in resurrecting the sovereignty that seemed lost forever. So, I'd like to finish off with a toast. It's early in the morning, but in your pockets and purses, you must have stuff. And I'd like to offer a hearty toast. A hearty toast to the attorneys and staff past and present, of NARF North, and to the attorneys and staff, past and present, of all of NARF, who together have carried so high the banners of Native people, tribal sovereignty, human rights, and the banner of the best law firm ever. A toast. Thank you. Oh, thank you.